It's Kristin who's our moderator for this evening. She's been discussing with our lovely panelists up here and is very excited to tell you guys some about what they do. Thank you. Good evening, and welcome to Catholic University of America Columbus School of Law. Tonight we have a special Women's Leadership in the Practice of Law event called May She Please the Court. I'm Kristin Mitcham, a first-year Catholic law student and a member of the Women's Law Caucus and your moderator for the evening. First, I'd like to thank Dean Daniel Attridge, the Office of Student Life and Special Events, the Evening Law Student Association, the Women's Bar Association of D.C., and our honored guests for supporting a special event this evening. This year, the Women's Bar Association is making its centennial celebration of the women's leadership in law. When the WBA was organized 100 years ago, women did not have the right to vote, they could not serve on a jury, and very few women were allowed entry into law schools to be licensed to practice law. In solidarity with those women leaders in the practice of law, our Women's Law Caucus decided to organize this special event for the law school to energize our women and men law students to serve our community and nation in the study of and future practice of the law. Tonight, 4 extremely successful women lawyers are going to share their own personal stories of their journey in serving others in the practice of law. I'm pleased to introduce to you Michelle Kallen, who is a senior associate of Paul Weiss. She has drafted numerous Supreme Court briefs and co-chairs the Women's Bar Association Amicus Committee. Michelle is clerked for Judge James Stanch on the 6th Circuit Court of Appeals. She has argued before multiple courts of appeals, including arguing and winning a case before the 6th Circuit during her 3rd year in law school. Erin Murphy, who is a partner at Kirkland Ellis. Her legal practice focuses on the U.S. Supreme Court, appellate, and constitutional litigation. She has presented legal arguments on statutory and constitutional questions before the United States Supreme Court and more than half of the circuit courts. She has appeared on TV and in publications to speak about the Supreme Court and appellate advocacy. She was a law clerk to Chief Justice John Roberts Jr. of the United States Supreme Court and to Judge Diane Sykes of the U.S. Court of Appeals for the 7th Circuit. She was a Bristow Fellow in the Office of the Solicitor General. She has been recognized by the National Law Journal as one of the nation's outstanding women lawyers. Maureen Mahoney is a retired partner at Latham Watkins. She founded their Supreme Court and appellate practice. Maureen was the first woman in history to be appointed by the U.S. Supreme Court to argue in front of the U.S. Supreme Court. She has argued a total of 21 Supreme Court cases. She temporarily left the firm for an appointment as Deputy Solicitor General between 1991 and 1993. Prior to entering private practice, Maureen served as a law clerk to the then Associate Justice William H. Rehnquist and 7th Circuit Judge Robert Specker. Finally, we have Lieutenant General Flora Darpino, who is a 3-star general and the first woman in history to serve as the Judge Advocate General of the United States Army JAG Corps. She has served the U.S. and overseas as an Army officer and as a JAG for over 30 years. She leads 10,000 regular Army and civilian legal professionals. Please join me in welcoming our honored and distinguished guests. The following questions will focus on how each of our panelists' backgrounds and experience has demonstrated the attributes of leadership and tenacity as reflected in their extraordinary success in legal practice. Our first questions are on career background. Michelle, when you started law school, you were initially interested in public interest law. What made you switch to litigation and appellate practice in a large law firm?
Well, first, thank you so much for doing this. This is a fabulous event. I kind of feel like if you're looking at a list of people and you're like, which of these things is not like the other, I'd have to raise my hand. So I'm still kind of at the baby phase of practice of law. I've been practicing for about seven years now. And while I entered law school with the goal of focusing on public interest, I actually don't feel like I gave much of that up going to a law firm. Part of the process in selecting law firms included, and I'm sure a lot of you, those of you who've gone through OCI or are thinking about it, might know this, but a lot of firms are extremely supportive of pro bono work. So I entered law school seeking a school that actually had a public interest program and selecting a school based on that. And after learning about how public interest law is practiced, realized a lot of firms do some of the major impact litigation out there. And the first firm I went to and the firm I'm currently at are extremely supportive of public interest. And just by way of example, in the last couple weeks, I've been spending a lot of my time working on briefing relating to some of the travel ban litigation going on. So I feel like over the course of my law school career and summering at a firm and getting to know people at firms, I realized there are a lot of firms, including Paul Weiss, where I currently am, that heavily support pro bono work, and you could do fabulous pro bono work, and especially when you're a more junior associate, that's really how you get some of the wonderful opportunities to argue appellate cases or district court cases, but often your first real arguments are done on pro bono cases, so you can really do public interest work, but also at a firm.
Maureen, can you tell us the difference between being an appellate lawyer and a trial court lawyer, and how you came to start the Supreme Court appellate practice at Latham Watkins?
Sure, but first I'd like to say she might look like she's too young to be here, but she sounds like she's supposed to be here. So, trial versus appellate. I wanted to be a trial lawyer. You heard my resume. I argued all these appellate cases, Supreme Court and other courts across the country, but I really wanted to be a trial lawyer. And even after I finished my clerkships, that was my goal when I went to Latham Watkins. And why did I want to be a trial lawyer? Because I actually think that trying cases is more challenging and more exciting than arguing appeals, because the breadth of skills that you need to try a case well it's the full package for a litigator. You've got to be able to handle the witnesses, put together the facts, cross-examine the other side, present the arguments to the judge, make sure that you've made all the evidentiary, decisions correctly, and argue your motions, understand the law. It's everything. Whereas being an appellate lawyer, the focus is more. I think the best appellate lawyers also know something about being a trial lawyer. But the focus is more academic. It's more on, because the standard of review for legal issues is de novo on appeal, those are the ones you're more likely to win. And so that's really where the focus of the strategy generally needs to be. So it's a little more academic. It's more reading, writing. You're confined by the record. You don't really need to meet with witnesses. You occasionally meet with a client, but I mean, it's fantastic. It's interesting and all of that. But when I was practicing and trying to become a trial lawyer and actually did some trials and some depositions, I found I was traveling all the time. And that's the problem with a really complex litigation practice. A lot of the cases will take you all over the country and indeed all over the world sometimes. And I was having children and I just didn't want to travel anymore. So I decided to become an appellate lawyer, and it worked out just fine. So anyway, but I would encourage anybody who's interested in appellate to still try some trial work, because the skills are really important for you even as an appellate lawyer.
And how did you start that practice at Latham?
When I returned, I was handling appeals for people even before I went to the Solicitor General. But I wasn't a specialist really, but lawyers within my firm, litigators who preferred to try cases then argue them, would hand them over to me sometimes to handle the appeal in certain circumstances. So I was getting appellate experience. But when I went to the SG's office and then when I ultimately came back, I decided that's really where I should focus all of my time and attention, and the firm was very receptive to starting the appellate practice. Very few firms had them at the time, but I was not the pioneer, I was not first, but I was first at Latham Watkins. So.
Erin, what inspired you to become a constitutional law expert and to want to argue in front of the Supreme Court?
Well, it all is, whole kind of appellate and Supreme Court practice is something that I sort of fell into. It was not what I kind of went to law school thinking about. I mean, it would have sounded interesting if I had been thinking about it, but I actually, when I went to law school, was really interested in national security law and kind of had a whole different career in mind. And I think that what I ended up finding out is the things that Maureen is talking about. I really liked the academic aspects of law. My background had been writing, and I really like writing, and I like reading, and I don't mind a job where I spend a lot of my time in my office by myself reading and writing still after 10 years of practice. That is what I do a lot of the time, and I really enjoyed that and found that that the appellate work was interesting. And then, I mean, once I started getting the opportunity to actually get to litigate issues about the Constitution, I mean, there's just kind of nothing more exciting, I think, when you're doing appellate law, and particularly before the Supreme Court. I mean, it's really quite something when you get to argue and briefing them, not just arguing them. I mean, most of what I do is briefing, not arguing cases, but briefing issues about the meaning of our Constitution. These still come up frequently before the court, which is an amazing thing, and it's a great thing to get to be a part of them. And I've always really liked history, and I like that constitutional law really is, in many respects, about history, because you're learning more always about, the going deeper and deeper into the idea of the structure of our government, and why we have certain provisions in the Constitution, and why things have operated certain ways, and all the history behind it, which I think is what makes it, constantly something kind of new and exciting.
And what does it take, or what is involved in being admitted to the Supreme Court bar?
It does not take very much.
Money,
right? Essentially, yes. You just have to have been the member of a state bar for 3 years and have somebody who is a member of the Supreme Court bar and sponsors you and pay a fee. So, but it's actually the admission itself is a neat thing that you can get admitted. A lot of admissions are done in person, and someone moves your admission in person before the court, before the arguments begin on a particular morning. And then if you're there to get admitted in person, and you stand up and get actually moved personally, and then you get to stay for arguments for the morning. So it's actually a neat thing to do, and a great way to get to go, especially if you can manage to have it arranged on a day when they're going to argue something interesting. Gets you into court for the morning, so without waiting in line.
General Darpino, what is the Judge Advocate General Corps, and how did the Army's values and ethics inspire you to become an Army JAG officer?
Okay, so I have to confess up front that I didn't ever aspire to be an Army JAG officer. So like Erin here, I sort of fell into it. I met a boy in college who was a reserve officer training candidate, and so he owed the Army, since they paid for his college, he owed them 4 years. We went off to law school, 2 different law schools, because I wasn't going to follow a guy to law school that I wasn't married to. You see where this is going, right? And 3 years later, when we were getting ready to graduate from our different law schools and get married, I kind of said to a professor, because I wanted to do trial work too, and I was very involved in litigation in the law school. And my moot court professor said, so which firms are you looking at? What are you going to do? And I said, oh, I can't. My husband is in the Army, and I'm going to have to wait to see where he gets stationed. And I'm going to have to take a bar exam and then look for a job. And he said, and you're not joining the Army because? And I thought, it really never dawned on me that I should join the Army also. And that's what I ended up doing. At the time I came in, there were only about 8% women, though. But what I did find and why we stayed is relevant to the question. It was the values, and that I serve clients when I'm giving legal advice who want to do the right thing. And very important decisions where they want to do the right thing. And the people you work with are doing very important work, and they want to do the right thing. And so it's for those reasons that I stayed. I found an organization that was values-based, And I got to be part of the moral and ethical decision-making process in my practice of law. So, but it was a boy. Oh, I'm sorry, we're still married, so the career and the marriage both worked out.
But you eventually became his boss, or he had to change to a different. You can tell that story real quick.
So when I became a general officer, it was a 1-star. You start out with 1 stars, and they put me in charge of an organization where he had the job he had wanted for his entire career, which was the chief of our litigation division that does all of our defensive federal litigation in courts throughout the United States. And since I was his commander, as he says it, my first official act was to get rid of the dead wood, and so I fired. The truth is they moved him to another job. But.
So we heard some of the different positions that the other ladies held during their career. What positions can you share with us that you had to hold in order to qualify for the position that you're in now?
Oh, the position I'm in now. You know, what the JAG Corps works very hard at doing is creating legal minds that you can drop into anywhere, be faced with a problem that you've never had before, and have the skill set and the confidence, using what you've learned over your career, and provide that advice. You just move out. You have no choice. And so, in Iraq, the first time when I was there, I didn't have any comms. I didn't communications. Sorry. My computer went down on a regular basis. I didn't have phones, and we dealt with issues that I hadn't dealt with before, and I had to have the confidence to make that decision. So what the Army does is try to put you into different areas of practice in different places every couple of years, so that your brain is used to saying, okay, I've never seen this before, but I know I can do it. And you start to have that mindset. You do your research and you rely upon your network and all of those things, but they create a person who is able to do complex problem solving in unique circumstances. And so what they did is move me every 2 years into different jobs. I focused a lot on litigation through my career in advocacy. But that they're creating that agile, adaptable thinker, like an appellate argument, in front of you never know what they're going to ask you. You have to be prepared. It's the same sort of skill set that they try to create for us.
The next couple questions are going to be about leadership. Michelle, you and I spoke previously about the difference between leadership of a mentor and a sponsor. Can you share with the group how you perceive the difference, the differences, and whether it might coordinate with the, Can you share with the group how you perceive that difference and whether it might correlate with the comparatively slow advancement of women in the legal profession in the last 100 years?
So that's a loaded question, but I'll take it piece by piece. So going to law school and having an interest in women mentors and seeing other women succeed in law, I always kind of thought of the word mentor. And after coming to DC and joining the Women's Bar Association, the WBA, which by the way accepts students, so we would welcome anyone here, both man and woman, who is not a member, is welcome to join. But some of the leaders at the WBA said, well, it's not important to only look for mentors in your career. It's also important to make sure that you have sponsors. And the difference is a mentor is somebody who might meet with you for lunch and give you advice and answer your calls and be available to you. But a sponsor takes it the next level. A sponsor is somebody who, let's say at your firm or at your organization, actually actively promotes you and tries to take that additional step to put him or herself on the line for the advancement of your career. And that's a distinction that actually really hit close to home, and especially as I become more senior in the context of a firm, learning that distinction has made a big difference, because it's not been that difficult to find mentors. People tend to be very generous with their time in terms of taking other people out, meeting them for lunch, or answering their calls, but finding someone in an organization to go out of his or her way to really help promote in a career is difficult to find. And a lot of studies and conversation has been around the fact that people often will sponsor people who remind them of themselves. And that's kind of how some of that relationship works. And the reality is, if you have particular types of people in leadership, and there isn't much diversity in leadership, and you're a diverse candidate coming through the ranks, it makes it that much more difficult to find somebody who will sponsor you and actively take that role in promoting you within the organization. And so this is something that I don't think is unique to women, but it's unique to any sort of diverse candidate in the workforce, even outside of law. It's very difficult to develop those sponsorship relationships when you have barriers of difference and beyond just gender, race, ability, disability. When you don't have diverse leadership, it's very difficult then to get people up through the ranks. And so I've been fortunate enough, especially in this city, to really develop great mentors. But I'll confess, sponsorship is something that's been very difficult to find. And hopefully over time, it's something that really develops.
Thank you. Maureen and Erin, were there any leaders throughout your career who fit the description of mentor or sponsor? Or have you been one of those to someone younger?
Well, I mean, I certainly owe many things that have happened in my career to Paul Clement. Paul is the partner that I've worked with basically for all of my time in private practice. I mean, really 100% of my time in private practice, and my entire practice as a lawyer, because the only thing I've done other than private practice was my year as a Bristow Fellow, and he happened to be the Solicitor General at the time. But so, there's a reason that I've been willing to follow him from firm to firm on our third firm now in private practice, and that's because he's been someone who's kind of served all of those. Done all of those things for me in my career. And I think the reality is a lot of this is more organic than kind of the idea of somebody, it usually works better to develop organic relationships than kind of the idea of someone being your formal mentor or your formal sponsor. And it's just someone who I've worked closely with and early on was part of the reason I wanted to keep working closely with him is because he was the kind of person who demonstrated to me early on that he was interested in advancing my career as well, and helping me get opportunities and going to bat for me. I mean, I would never have gotten my first Supreme Court argument if he hadn't gone to bat for me. I frankly, I'm not entirely sure how it happened, because I think he sort of made it happen, So, but you need to have people in your career who are willing to go to bat for you at the right moment. And I think one of the things, a lot of people think so hard about how to make those moments arise and how to make the ask and to always be trying to find someone to put them out there. And to me, it's much more important to develop the relationships so that when the opportunity arises, the person wants to go to bat for you. And, opportunities don't always arise as frequently as you would like in life, but it's so essential to have somebody who's ready to try and make it happen for you when they do. So, I think just working on developing those long-term relationships with people is key, and I've been fortunate enough to have that, and it's been a huge part of why I've had the opportunities I've had early in my career.
I guess I think I've had a lot of people that might fit that description, but I would say the most important mentor or sponsor I had was Chief Justice Rehnquist, and that's a pretty powerful sponsor to have. But I say this because for people who are thinking about clerking, a lot of times the judge you clerk for can turn out to be a very important player in the formation of your career, because judges know people, and when they vouch for you, it carries so much weight. When a judge tells a lawyer or a friend or whomever, or a professor or whatever kind of job you're trying to get, she's great or he's great, it's just incredibly helpful. And in my case, I'd actually, when I clerked for Rehnquist, he was an associate justice, he became the chief, and so when they had there was a case where they needed to appoint a lawyer, which you mentioned, and he persuaded the court to appoint me. Well, that was just a huge breakthrough in my career. It's very hard to get your first Supreme Court argument. It's really hard, and so that for me was a major stepping stone to an appellate career. And I guess I'd say two things about when you're thinking about mentors and sponsors. I agree. Mainly, it happens organically. If you do a great job for somebody, they're often going to want to promote you. They're going to want to help you. I mean, become important to their practice or their life or whatever. And if they're a nice person on top, they'll usually help you. So that's a key. The other thing is that while I think it's great to have women mentoring women, and but men still open a lot of doors. So don't just go looking for women mentors, because what you really want are people who can open doors for you. And if it's men, fine, let it be men. Whoever's going to open the door, that's really just great. And the other thing is, if you are going to clerk or in practice, don't let ideology be the determinant of who you think you want to work with and who's going to be good to you long term. There's sort of this assumption that if it's a judge of a more liberal ideology, they're going to be better for the women law clerks than the judge or the justice who is conservative, and it wasn't my experience at all. I mean, they didn't come much more conservative than Rehnquist, and he just couldn't have been better. And people are often shocked to find that Justice Brennan, who was on the court at the time, his biographer actually reported that Justice Brennan said that if the president appointed a woman to the Supreme Court, he thought he would have to resign. He didn't hire women law clerks except in a couple of instances. He did later on, after Sandra Day O'Connor joined the court, I believe. And I'm not trying to malign Justice Brennan as much as I'm trying to say that whether somebody is going to be good to you and help promote you and help your career, it doesn't really turn on whether they're a conservative or a liberal. So anyway, just keep an open mind about that.
If I can just add one thing to pick up on something that Maureen said. I mean, it makes all the difference in the world to work for nice people who are just good people. I mean, somebody who's really important can open lots of doors, but at the end of the day is extraordinarily difficult, isn't really going to want to open doors for anyone else at the end of the day. And I just think it makes, when you're thinking about a law firm or whatever it is, a judge, I mean, I've been fortunate enough to work for a judge, a justice, and a partner who are just the type of people who want to see you succeed, and that makes all the difference in the world.
General Darpino, the Washington Post did an interview with you in 2013. In it, you talk about your father and how his message to you was to always work your hardest and always give your best effort. In the same interview, you talk about your supervisor at your first assignment and that he said to you, "I told them not to send me a woman, yet here you are." How did your father's leadership help you to overcome this initial gender discrimination you experienced in the Army?
Okay, so 30 plus years in the Army, so this is 30 plus years ago. There were, as I said, about 8% women in the Army JAG Corps. There are now close to 30% women in the Army JAG Corps. Okay, so it's a very different corps. And so when I walked into that office and he, said, "I told them not to send me a woman, but they sent you anyway." I remember thinking to myself, well, I chose a male-dominated profession, the law. I chose a male-dominated organization, the Army. So I shouldn't be too shocked by that statement. And it's how I react to that statement that's going to, basically define who I am as I go forward in this career, because I had signed a 3-year contract. And this of course didn't happen at that exact moment. At that exact moment, I was like, this is like when I went home that night and started thinking about it and went back to my office. And I remember saying to myself, that was a two-phrased question. Don't we all love the word? We're all like in the legal profession, right? I said it was, the first part of that sentence was, I told them not to send me a woman. The second half was, and they sent you anyway. And I thought they, these wonderful people that they are, made this decision to send me, even though he told them he didn't want a woman. And so they must have some faith in me. And this is where my father comes in. And I thought, well, you know what? I'm gonna work really hard, and I'm going to show him just how good this woman is. And I just worked to my like I was taught, work very, very hard and do your very, very best in everything you do. And I'm telling you, he was my biggest cheerleader. I became his #1 captain by the time it was over. He hadn't been exposed to a woman before, and so he was completely wrong. And I think that, because I didn't shrink and gave my very best and showed my very best, he learned a lesson. So throughout my career, when I encountered the same sort of situation, I remembered that. And I always, run into it more than once. And I remember, and I've always said to myself, I actually have the power here. Because I'm the one who knows how good I am. They are underestimating my ability, which means that I may be able to maneuver around them pretty darn quickly. And so I've, since that time, used it as my, superpower. That they are underestimating me. So.
Thank you. My next question is about tenacity. Maureen, President Bush nominated you to serve on the U.S. District Court for the Eastern District of Virginia. Nevertheless, Congress failed to confirm you before President Bush's term ended. Please relate to us how you persevered following this challenge.
Well, I was very disappointed. I want to say that. I was very disappointed. I hardly ever cry, but on election night I cried. I really wanted the job. I wanted to be in the Eastern District of Virginia. Felt like the right time in my life. I told you I really wanted to be a trial lawyer, so being a trial judge was really a very exciting prospect. And I live in Alexandria. The courthouse was going to be just down the road. This was great. The chief judge had called me and said, Maureen, now you should come down and pick out your carpet, because they were just building the new courthouse at the time. And I said, I think that sounds like bad luck. I should have picked the carpet. It didn't matter anyway. But I had a very soft landing. I mean, after I got used to the idea, I continued in the Solicitor General's office as a deputy, arguing like incredibly important cases before the Supreme Court, and then I returned to a very lucrative law practice at Latham Watkins with some of my best friends in the world, where I stayed for over 30 years. So the way my career progressed, like most things in life, there's a lot of times there's just not a bad outcome. There are many things that I have and did that wouldn't have happened if I'd gone on the bench, and I'm sure I would have loved the career I had if I had. But it's just politics, Judge Garland was supremely qualified, but it's just politics. That's what happens. If you get nominated in an election year, a lot of times you don't get confirmed, and life goes on, and other good things happen, instead. So it worked out fine.
And I'll open it up to the rest of the panel. Are there any career challenges that you'd like to share with the group and how you persevered? No challenges.
Nobody had any challenges.
I will say, when I went into private practice and to do appellate and Supreme Court law, I envisioned going to the Solicitor General's office. And I have always wanted to work there. I loved the year that I had there. I tried to get a job there a few times and it didn't pan out. And that's a kind of a really important job to have for somebody in an appellate and Supreme Court practice, mainly because it's where you can first get a Supreme Court argument, which are very, very hard to get. I was pretty devastated the first couple of times I didn't get the job, and then I got a Supreme Court argument in private practice out of nowhere, which sort of never happens and probably never would have happened if I had gone that route. So I think it is the kind of thing where it's hard to tell yourself in the moment, especially when you really have, a lot of people they've got plans about, I thought in this many years, this will be the next step. And sometimes the next step isn't what you thought it was for good reasons, and because there's something just as good that you hadn't really thought about. So and I still, when things, there's things I want that don't work out in my career, and it's always hard in the moment to think about how something better than what you think is the best thing possible is going to come along. But so far, it usually works out. So I'm hoping that trend will continue.
And I think part of it is also how you let it work out. So you can face failure and then just wallow in that and have that be your life story, or you can face failure and say, okay, this didn't work out, and then face another direction and go for something else. So something that might hit a little close to home to students is when I was a 3L. This was back in the days where there was this very structured system to obtaining a clerkship. That I understand is now completely dead, but Oscar was the kind of platform that judges use, and there were very strict deadlines by which you had to apply for a clerkship. You got calls for interviews at specific days, and you basically had to, the tradition was you accept your first offer, and so you strategically time all your interviews, and so I put together my applications, and at the time, my husband was in med school, so he had one more year of med school while I finished law school. So my goal was to either stay in the area or go back to our hometown. And I put together applications and mapped out all the dates of when I can expect the phone calls and go through the whole clerkship application process. And the day came, and despite being a good student and working really hard, I didn't get a single call. And so I kind of moved forward and got ready to move to Los Angeles, where I was going to start my job at a firm. And but still, there was a judge who was recently nominated, and she was, in theory, she could have gotten confirmed a year before when she actually did. But the timing just happened to work out. She was in Nashville, the same city where we were in law school, where my husband had one more year of school. And literally the day before the moving van was going to show up at our house to move me out to Los Angeles, I got a call and received a Sixth Circuit clerkship in Nashville, where I got to then have my dream clerkship with my dream judge and stay in the same city with my husband. So had I wallowed in that clerkship experience, I would not have continued applying to other clerkships. And so I think, thus far, the experiences that seemed like failures, a lot of times now looking back on them, ended up being the unique opportunities that really kind of drove my career in a better direction. So I think a lot of it is our own attitude on how we address failure.
Yeah, I never would have had a house in Nantucket if I'd been a judge on this.
Definitely a positive. Maureen, the legal Times described your demeanor before the Supreme Court as unruffled and poised. Observing you are able to professionally answer difficult questions from Justice Scalia. The American Lawyer described your first Supreme Court argument as well-schooled and disciplined. Can you tell us about the first argument in front of the Supreme Court, how you prepared, how you felt, what were you thinking, and if you had any routines?
Yes, I remember it all very clearly. What I really remember is that I had very severe performance anxiety for the first argument, for the last argument, and every argument in between, and not just at the Supreme Court, but at every court where I ever argued. Not all advocates actually suffer from severe performance anxiety, but I'm one that does. And all I can say to you is that stress can be your friend. I always felt that because of that anxiety about speaking, that it caused me to prepare more thoroughly than some of the advocates who were more comfortable. Because I always felt like the only way to combat that anxiety is to know everything. And so I would, literally, just spend, for Supreme Court arguments, hundreds of hours, learning everything I could, practicing every question I could, and I did that for the first argument, and I did that for every argument thereafter. I mean, sometimes you couldn't do as much as others, depending on what life had in the way, but it was always the same in terms of just really, really trying to be exhaustively prepared, so that when I stood up, I could feel like, okay, I'm nervous, but I know more than anybody in this courtroom by far. And that just, gave me, a whole lot of confidence. There was extra pressure for that first argument, not only because it was my first, but also because I told you I'd been appointed by the court, and so I didn't want to embarrass Chief Justice Rehnquist. He had, told his colleagues that they should appoint me, and I just didn't want to, show up and have them feel like, what's she doing here? So, so I practiced a lot, and practice does help. The other thing in terms of rituals, both, what I think some people know this about me, but I would always have a donut before an argument in the Supreme Court. And in the afternoon arguments that I would have in courts of appeals, I would have a cookie. That doesn't get reported as often, so it's very important you know that, because cookies are better in the afternoon than donuts. And this really was a carryover from, I swam when I was a kid, swam competitively, although I was no good. But I had a coach that told me that if I ate a candy bar right before the meet, that it would really, give me a sugar high and help me. And so I've been doing that ever since. And it's a really good excuse to eat something I love. So.
You don't eat the powdered donut, though, do you?
I don't eat the powdered donuts, no, but I would if that was the only available. I don't choose them if I have others to select from. So.
Erin, you and Maureen have been ranked as top lawyers, but also as top women lawyers. Is it a good thing or a bad thing to distinguish women from men in the legal profession?
Well, I first have to say, as a side note here, I mean, so it's a real privilege for me to get to be here with Maureen Mahoney, because when I was in law school, if you asked anybody who the best female advocate was, it was always Maureen Mahoney, and they would probably tell you she was one of the best advocates no matter what you asked, because she was, and it's just amazing. And so it was someone that I really, looked up to and thought about hoping to argue. Like, I obviously kind of did something wrong, because my press coverage was not like that I'm, well prepared and very all these wonderful things. I was most recently described as young and brash.
Oh, that's good. That's very good.
It's a different way to go. Whether that's something that would have been said about a male advocate is another question to have. But I think the reality is, particularly in Supreme Court practice, I mean, people frequently will still ask about who the best female advocates are, because there just aren't a lot of them. It's great now that there are a lot more women doing it in the Solicitor General's office and getting arguments that way, and hopefully that will all, lead to there being more women who argue cases in private practice. But last year, I mean, I was shocked when I learned at the end of the term that I had this sort of unusual circumstance of arguing 2 cases last term, which is certainly not, I mean, I don't anticipate to get to argue 1 case most terms. It just sort of happened. And there were no other women in private practice who had it. And apparently I was like the only woman in all of private practice that argued that wasn't appointed by the court the whole term, which was just, I mean, it was anomalous. It's not usually quite that dramatic, but the numbers are really, there's just fewer women doing it. And I think that's part of why, and I think that's true in a lot of respects, it's not just specific to Supreme Court and appellate practice. I mean, there are a lot of women lawyers, but there are fewer women lawyers who go and stand up in court and do the court work, and there still are fewer, today. So I think part of it is that people think about it that way just because there's fewer women who do it, and sometimes it's in a way of wanting to know who the good women are out there to see there be more of them. So, but I think it's less at this point something that people think of in terms of people having sort of different skills or it making a real difference. It's just that it's still unfortunately sufficiently infrequent to have women in a lot of areas of the legal profession that it's a question that's relevant to ask still at this point.
Do you have anything that you would like to add?
Just that in general, my view was publicity is good. So if you're trying to get known and somebody wants to write an article about the top women Supreme Court advocates or whatever, I'll take it because it's hard. Right? It's hard.
I would never have been on the list of just outstanding lawyers in Washington, but
well,
somehow I was on the list of outstanding female lawyers.
But it does, so I mean, there's a little barb there. You sort of feel like, well, wait a minute, but I do think it's still good to get your name out there and clients see it. But it was interesting. I once had a case where I was hired to represent the United States House of Representatives for a challenge to use of sampling in the census for purposes of the reapportionment. And I was the general counsel for the House of Representatives interviewed a number of leading, appellate advocates, and I was selected. And this was pretty early in my career, so I was kind of surprised that I got chosen. And I asked her one time. I said, "So did you pick me because over John Roberts? Because I'm a woman. Because she's a woman." I thought, well, that was probably it. She said, "Are you kidding? I picked you because you were the only one who said we could win." Sometimes you think this is going to be your big advantage, and it's really not about that at all.
Right.
But take what you can get.
General Darpino, did you ever feel that as a woman serving as an officer and as a lawyer, you had to perform at a higher level just to be considered equal to your male officer and lawyer counterparts?
It was very, very evident that, because you have to remember how we work. Every year or 2 years, we move you from one job to a different job. Every 2 to 3 years, we move you to a completely different location. And so there's this churn in all of our organizations. So you're basically reestablishing, when you're younger, your reputation repeatedly in every room you walk into. You get to a certain grade, after you've been in for maybe over 20 years, that you're a more senior officer and you're only dealing with folks that are about the same as, senior as you. And so they kind of, your reputation. But that takes quite a while. So that happened on a very, very regular basis. And I think you probably could tell that I'm an extraordinarily optimistic person. And I believe that, who you see here now, there was a lot of false confidence in the beginning where, I remember what my parents taught me and say, I'm taking this, I'm taking that hill, as we say in the Army. I can do this. I am going to walk through that door and I can do this. But over time, I think I, gained that confidence, but always recognized that I had to outperform my male peers to be considered their equal. But once I was their equal, they were like, oh, she's really good. So then I feel like I always got a bit of a bump, because then I became that woman who's really good. And then I was able to bring other women along with me, because then, like I said, with that first boss, suddenly it wasn't like, I don't want a woman. Well, I want a woman if she's like Flora. And then they saw more and more Floras out there, and it just changes the climate. People often ask, what would you, if you met, 25-year-old Flora, what would you tell her? And I always say, and I really think about this, and I tell my daughters this all the time. I have 2 daughters, 26 and 24. You're a lot better than you think you are. Have the confidence to do it. And that's what I would tell myself.
Awesome. going to ask each of you guys one more question, then I want to open it up to the audience to see if they have any questions to ask. Maureen, what advice do you have for the 1Ls who are currently preparing for their final appellate oral arguments?
Well, I think there's two things that are really important for preparation. And the first is you've got to figure out what legal standard you're asking the court to adopt. And a lot of advocates, it's hard to do. It's hard to figure it out. It's hard to make it crisp. It's hard to make it, work for your case and work for all the other cases and be consistent with precedent. And so I think a lot of advocates, when they're preparing, they kind of skip it. And it's really essential to grounding your preparation and making everything fit together and really giving you the ability to answer questions with confidence and have a position that you can hold on to, answer hypotheticals, that sort of thing. So you do the work by reading the cases and looking at the fact patterns and coming up with a rule of law that'll work for you and not make a mess in other fact patterns. And the second thing that you've really got to do is you've got to think of virtually any question that might be asked and come up with the best answers. They need to be concrete, they need to be short, you have to have practiced them. I literally would spend most of my time while preparing just writing down questions and come back later by topic and come back later and figure out what the answers were. And then some of them were easy and I'd just put them aside because you know them, you don't need them. And then isolate what are the hard ones and keep practicing them, make those answers more crisp, sharper, get them better, and practice, practice, practice. And that includes memorizing key, citations from the record or quotes or whatever it is you need. And you do those things, you're going to be good.
And before you go into your argument,
eat a donut. Unless it's in the afternoon and then you eat a cookie. Yeah, right.
These are at night, they're at 6:30.
Cookie would do. Yeah, cookie. Cake. That would be, I never had a 6:30 argument. Cake, that would really.
Erin, what advice do you have for students who want to pursue a career in constitutional law?
Well, I think most constitutional law is really going to have kind of intersect a lot with appellate law, and it's probably going to be in the same respect. So, I think the biggest advice I'd give if you're looking to go in that direction at all is to really focus on writing. I'm always shocked to hear that people can go through law school without ever, maybe you have to write something in your first year class and then you kind of never do again. And if you have opportunities to take classes where you have to write a brief, do it and write a brief and get better at that, because writing is a huge part of any type of appellate law. It's a huge part of, if you're doing constitutional law, of course the research is going to be a lot of it, but at the end of the day, you're going to be producing something. And I just, when we have associates who come to work with us, that's what makes all the difference is, people who not only are very smart and can think about it, but also have put the time in to learn how to really get the thoughts out and communicate them, which is going to be the same thing with your oral advocacy skills. But and generally also I'm a big fan of in law school finding opportunities to do real things that are that force you to stand up and do an argument or whatever it is. Finding those are great because there's a lot of theory in law school, but it's always helpful to have had a little bit of practice before you go into your legal career.
Michelle, what advice do you have for current law students that would help them to successfully transition to their postgraduate practice of law?
Well, one thing that continues to make a big difference is staying close with classmates and developing relationships with the people sitting next to you. You'd be surprised how many job doors open, how many unique opportunities come about just from your relationships with your classmates. About a month ago, I got in touch with a friend who I haven't spoken with since law school, but I ended up in his city in Alabama, and it turns out that thanks to kind of his connection, I was able to go after a hearing, have lunch with Judge Pryor, who was one of the judges who was being considered for the Supreme Court vacancy. And so it's those relationships that also come back to some of this mentorship, sponsorship idea, but it's human relationships that really give opportunities. You can have the perfect resume on paper, but if you don't have a relationship with anyone and you can't maintain relationships with people, it's very difficult to advance a career. And the flip side is you might have received a B in a class or had something that seemed like an obstacle, but if you have relationships with people, that trumps a lot of the kind of little marks on a resume. The second thing is really get to know your professors. I mean, evidenced by the fact that our last president was a common law professor. Your professors are people who, one, know a lot of wonderful things, but also, two, know a lot of wonderful people, and three, themselves are likely very wonderful people. So having relationships with them and having them start being your mentors or ideally a sponsor is really what can kind of get you going over the course of your career. And once you develop those relationships, maintain them. And it could just be an email every so often. It could be liking their promotions on LinkedIn and just sending a quick congrats, but something that keeps them thinking of you by just doing nice things for them. One, because it's the nice thing to do, but two, it'll likely open a lot of doors for you.
And General Darpino, what do you wish law students knew about the JAG Corps, and what advice do you have for students who wish to serve others in that capacity?
I think that what law students should understand about the JAG Corps is that you're going to be pushed into jobs before you think you're ready, as I've been kind of describing. I often wonder if I was left to my own devices, if I hadn't joined the Army, if I would have held myself back, kind of like I said before. But the Army didn't give me that choice because they pushed me into jobs before I thought I was ready. So if you're interested in the practice of law in the Army, then you have to think about what the skill set that we're looking for is. And really, it's someone who has the intellectual ability to be agile and adaptable, where you're not gonna do just one thing and get really, really good at it, because we're gonna make your brain work in a different way, issue spotting across a spectrum of things. And so that's if you do a career. You come in for 4 years, that's different. You could do just one or two areas. The second is you were talking about interpersonal skills, and that's critical for us. We have nowhere to hide anybody. We're in a dual profession. You're in a profession of law, and you're in the profession of arms. And so in the profession of law, you are advising people right out of the gate. And every person is on the field playing the sport. There's nobody hidden anywhere. And so you have to have that ability to communicate on a personal level. And you have to speak your client's language. And that may be like big guns and things that you have no familiarity with. It's not the law necessarily. You have to translate it to their language. So interpersonal skills are extraordinarily important. You have to kind of like our culture of soldier. Like I said, profession of arms and profession of law. 3 weeks from now, I will be out there taking our physical fitness test. It will be my last as I retire this summer, but I'm still required to do that twice a year. It doesn't matter, because we recognize that although this is our weapon system, if our body gives out on us, and it's the same for appellate arguments and all the, everything else, if your body gives out on you, then your weapon system no longer functions. And so we're required to be soldiers just like everyone else. So if you don't like physical fitness, you're probably not gonna like the arms. Push-ups. Which is a story, but I'll say that if anybody wants to hear my push-up story. I found out after I had signed my contract, and my husband swore me in our apartment in New Jersey. And then the last thing is you're not gonna own a place in Nantucket. And don't do it. That's it. So.
All right, I think we have time for 1 or 2 questions, if anybody has anything. Alicia?
I have a question for you, Maureen. You were talking about how you have a lot of anxiety and performance anxiety before arguments, and I definitely have that. And so I've kind of ruled out, I'm a 2L, and I've kind of ruled out any kind of trial practice just because I'm so anxious before, like our oral argument is when I just sat there shaking the box. What led you to still push past that?
Because I was pretty sure it was what I wanted to do. I really like argument, and even though I was afraid and always afraid. And I have to tell you that while it's not all of them, a lot of advocates have performance anxiety. And in fact, Beverly Sills, I don't know if you guys know who she is, but very famous opera star. I saw her interviewed once where she said she felt like she was going to throw up every time she sang. And she was one of the most brilliant, vocalists in the world. So it just depends on how much it matters to you. I mean, how much, if you like other things just as well, then don't bother, But if you're really drawn to it, just if you do it more, it will probably feel a little bit better, and you'll figure out if you can manage the stress that goes with it or not. But if you can't, then yeah, do something else. There's lots of interesting things in law.
You definitely shouldn't let it stop you from trying ones. I always thought I was going to be too nervous to argue cases. And the first argument I went to, I was so nervous. I was by myself and I think I got up and left the courtroom like 7 times before it happened because I was there too early and everything. And then for me, the reason appellate law worked well was because they ask you questions. And the moment someone asked me a question, I forgot that I was ever nervous because you're in it. And if there's something like, I think it's probably the same for people who really enjoy trial work, but if you can find that once you're doing it, you lose the anxiety, then, then you can learn to manage the anxiety before. If it turns out, some people actually just don't like it even once they do it, they're anxious the whole time. But if it's the anxiety of doing it and in the moment you can lose that, then I think and you got to do it a couple times to figure out which type of person you are.
And it's what, exactly what Maureen said. She gets her strength from it because then she practices, she makes sure she knows it, so you can turn it to a positive.
You are an optimist.
I am an optimist. Not only is it's not even half full. I can water a lot of plants. And stress is your friend.
And I think there are studies that bear that out. I mean, if you're prepared, so if you're unprepared, then stress can make performance worse. But if you're prepared, studies show that stress actually makes your performance better. And also, see how you feel afterwards. If you're really, really nervous before, and then forget about it during, and then feel a rush after, then maybe it is right for you. It's almost, arguing before a court is almost like a roller coaster, right? Like the best roller coaster is you're a little bit nervous before. While you're experiencing them, you don't have the capacity to really kind of think through what's going on. And then you get off and you're like, this is awesome, I want to do it again. And then you repeat the whole thing over. That's it.
It's great now.
Thank you. Professor Kelly?
When I was driving with my daughters downtown to the Women's March in January, we saw an elderly woman standing on a corner holding a sign that said something like, I can't believe I'm still protesting this stuff. Which struck me as certainly the way I was feeling about it. And so I wondered if any of you would comment on how you remain optimists in light of how discouraging progress seems to be on women's issues. Somebody other than General.
I worked at a major law firm, and I worked there for over 30 years, and I knew the place well, and it was a meritocracy, and there is just no, sure, was there maybe some guy there that, didn't like women as much, maybe, but it was a meritocracy, and so I feel like the world has changed a lot. They didn't used to be meritocracies. They flat out just didn't hire women, once upon a time. And I think that one of the problems, and a lot of people don't like to hear this, but some of the disparities are attributable to choices that women in general make. And the way I look at it is, as long as women value being with their children more than men value being with their children, women are going to be at a permanent professional disadvantage. And so what we need to change is we need men to want to be home with the kids just as much. I didn't want to give up any of the time I spent with my children because I felt like, motherhood is a joy. It's not a burden to be shed. But as long as the guys just don't view it as very important, they've got an advantage at work because they work harder, and that is an advantage in a meritocracy. The more you work, the better you get. So I just think that what the change that's coming, and I think it's happening, is men starting to want to be home more with their kids. Latham didn't have paternity leave when I started. If any man asked for paternity leave, they probably would have thought he was very odd. Whereas now it's absolutely standard. So I think it's coming. I really do. I'm very optimistic. But others may not feel that way.
No, I think the reason that I always feel optimistic, and I guess I wasn't in the workforce yet when it was so clearly discriminatory, but I just, while you can always point to lots of bad statistics and all of that, I never encounter people in my practice when I was in school. I don't encounter people who think about it and don't want to see women do well. It's really the opposite. Particularly now, just recently moving to a big firm, my goodness, they couldn't be more interested in having a female partner that they want to promote and do all sorts of things. And it's not all a perfect system, and there's a lot there that isn't quite right yet, and women have to figure out the best way for them to network and the best way for them to advance themselves, because we do things a little differently. Sometimes it's in our nature to be a little less aggressive about things in the workplace, and and I don't think women all have to kind of change that. But to me, as long as you continue to encounter people who actually are positive and receptive and want to help and want to see women succeed, then that gives me hope that we can all kind of work together to find the way to make it, to get past whatever barriers there are still to, real equality in the workforce.
I think there's a micro level to the question and macro. So in terms of micro, selfishly, in some ways, I love the fact that every time I walk into a hearing, it's assumed that I'm a secretary. At best, they assume I'm a first-year associate. And it's great, because then the bar is set really low, you're underestimated, and people don't know that their legs are being chopped off until they're already half off. So good, make the challenge on me easier. On a macro level, it's somewhat disheartening, right, to see that women have been 50% of law school classes for a very long time, and the numbers in terms of leadership at firms are not reflecting that, particularly if you look at equity partners. And so a lot of firms have multiple tiered partnership structure such that they're non-equity partners, and there are larger representation of women there. But then when you look at the equity levels, the numbers are extremely low, akin to the percentage of women who regularly appear before the Supreme Court. So that is somewhat disheartening that time hasn't solved the problem. But at the same time, we are making strides, and it's a matter of talking about it, having events like this, and doing what we can to identify the sources of some of these issues and work through them and talk through them, but also not just focus on women, focus on men as well. One of the things that drew me to my firm, Paul Weiss, is that we actually currently have 3 men out on paternity leave, but not the paternity leave where you get 2 weeks off and you come back, whereas the women get 6 months. They have the full leave as the primary caregiver, where they have the time to develop that relationship with their children and that bond, and so that they could work at home, be involved at home as much. And I can say 100%, there is no way that I could focus on my career and make career advances if my husband wasn't as involved as he is with our son. And the times that he's been traveling, I can't fathom how single parents do it, mothers or fathers. And so it is a matter of all of us supporting each other so that we can have this balance of home and work life that we need to advance in both.
Okay. Well, thank you very much for coming. We have a reception afterwards. If you guys want to hang back, we have a little photo op that we want to take with the Women's Law Caucus, and then we'll all enjoy some food and some drink. Thank you.